morning and welcome to our Health and Care Services Immigration webinar. This is the second in our series. So we did the first part of our immigration updates in the summer. So thank you for coming back, those that were part of that. If you want to watch the first part of the webinar series, then a link is available so you can still watch that. But thank you for joining us for part 2. So this is our autumn update on what's been going on in the world of immigration that's impacting your recruitment of an international workforce within the health and care services sector. So today I'll be your host along with my colleague Sara. So my name's Sacha Wooldridge. I'm partner and head of the immigration team here at Birketts in the London office. And Sara is our senior associate in the team and is our care sector lead specialist advisor. So it's been a busy world in immigration in many respects, and which is not unexpected this year. So immigration remains a very hot topic in the political landscape, and that's been impacted very heavily by lots of changes that have been going on in government as well. So in September this year, due to a cabinet reshuffle, we ended up with a new Home Secretary. So the previous Home Secretary was Yvette Cooper, has now been replaced by Shabana Mahmood. I had the privilege of being at the Labour Party conference to hear directly from her back in September. And it was really fascinating to hear from her. She'd got on top of the brief quite quickly, would be my assessment, but lots of momentum for change and to really make a stamp in this field. So I think we're going to see lots of changes still to come. And as part of her taking over as the new Home Secretary, there was a change in the ministerial team completely. So there's a new illegal migration minister. And probably most relevant, of course, for this webinar is the new legal migration minister, Mike Tapp, who I didn't yet have the privilege of hearing from directly, but have seen lots of ministerial briefings and written exchanges from him advising on immigration changes as they're coming through. So we're seeing lots of activity in a very engaged ministerial team driving through changes that will then start to feel within business. But despite there being a big change in the ministerial team, I think overall the direction of travel is as we expected from earlier in the year. So if you can remember all the way back at the start of the year in spring, the government announced a white paper on immigration that set out a general direction of immigration policy that we were expecting, which will be no surprise to you to see that the government are really pushing on reducing net migration, and that includes reducing legal migration and routes into the UK, including for workers. So that still remains the key objective. Obviously, under a new Home Secretary, we might see some tweaks and changes, but overall, that is aligned to their manifesto commitment. And that white paper was setting out objectives throughout the Parliament, so until 2029. So generally speaking, I think we're on track for a continuation, really, of the direction of travel on immigration policy. We did also already see some of the new changes starting to be implemented. So back in October, we had the new statement of changes, and that introduced some further implementation of those white paper policy objectives. So a continuation of that, and I'll talk you through some of those changes as we go. But what I wanted to do is just to take a moment to really set the scene. And as we say, the general government objective and political will is to reduce net migration into the UK as a whole. Now, obviously, the government can't directly encourage people in terms of emigration. So the only sort of facet of net migration they can control is immigration to the UK. So I thought it was a really interesting graph that I could share with you there from the Migration Observatory, which showed the rapid decline and really sort of falling off the cliff of immigration numbers in terms of work visas in the UK that have really come into effect since 2023. So if you might remember, the previous Home Secretary under the old government, under the Conservative government, James Cleverly, introduced quite a few changes to skilled worker and the health and care sector visa. And from that time and a continuation of those policies, then we've seen a huge drop off in the number of work visas that have been issued, and in particular in the health and care sector, which you can see on the slide. And I say that's a very intentional government policy. So we had still seen, and there's still large numbers of work visas being issued. So as of March 2025, 192,000 work visas still being issued. So still lots of visas coming through the system, but far fewer than there were previously. And that had been a result of, we've talked about the Boris wave over the autumn, and how the government are looking at that. And that's really because the immigration rules in many respects were eased after Brexit. And that was to counteract the impact of losing free movement. And obviously since then we've started to see a reduction in the various policies to limit who can come in subsequently from that. But of those substantial amounts of visas, 192,000, 12% were granted to care workers. After the care worker route, the non-senior care workers were available for visa sponsorship from February 2022. So big numbers. But in particular, under a Labour government, what we've seen is a lot of concern around exploitation of workers, and people abusing the route in the health and care sector in particular. So the government found that there were rogue traders setting themselves up as care home operators that were potentially not even a care home at all, or recruiting more people than they needed to facilitate entry into the UK. So the Labour government are taking a real focus on making sure there's a reduction in opportunities for exploitation of workers, and trying to resolve those issues. So that's included, looking at sponsor license holders, doing more compliance checks, as well as reducing the routes and visa sponsorship going on. One thing that they have also done, which has started with a particular focus for the health and care sector, but we have also started to see being rolled out to other roles and sectors, is a ban on dependent family members. So there was a lot of talk by politicians around the number of dependent family members that were coming with care workers. And as I'm sure you'll be aware, there's been a ban on new dependent visas for care workers since March 2024. Now, if a care worker was already in the UK prior to that date, they are still, even today, able to bring family members into the UK, but I say only if their original work visa was granted in the health and care route before that time. Anybody that's newly moved over into the health and care route, who are care workers, so under the particular care worker job codes, then you can no longer bring dependent family members into the UK. And also driving the reduction in visas overall is the increase in salary thresholds. So this is applied not just to the health and care sector, which we've seen a general uplift in the minimum salary required, but for all skilled workers on visas. And again, that's really been driven by a want to avoid undercutting of the local labour market, and to improve working conditions, to make the sector more popular for domestic workers to come and do those roles, rather than relying on immigration to fill those gaps. So overall, that's a good thing, but obviously puts a lot of pressure, given that there's a lot of government contracts which really control the price that you can pay for the workforce. So that's a difficult area that everyone's trying to manage and balance. And then notably, of course, that I think a lot of the sectors still coming to terms with and adjusting to, is a ban on new health and care sector visas for care workers since July 2025. So if the workers are already in the UK, they can change employers, or they can switch from other sorts of visas to move into the care sector, but we can't have workers for people who are based outside of the UK at this point in time. So I think we'll continue to see a big drop off in the terms of the number of visas of people coming into the UK on that basis. And just building on that, then I also wanted to share this next slide, because it really shows the impact on numbers, the change in policies we've had specific to the sector. So I just thought that was quite an interesting visual representation of the changes in policies and what that's done to the numbers, which frankly, if you're a government minister, really, marking their own homework, that looks like a pretty good result for them. Obviously, what that does in terms of impacting pressures on care providers, what that does in terms of frontline care provision. I think we'll continue to see that play out to be quite a difficult environment to operate in, but certainly from a numbers perspective, it's doing the job that it was intended. But as I say, we're seeing, obviously, as you would expect, the number of dependent applications are now coming down. So overall, there had been, a fairly large spike in dependent applications for care workers, and obviously in line with those rule changes, they've come down dramatically. So the peak for that was in August 2023. And as you might expect, it's really fallen away very dramatically, so that by September this year, there were only just over 3,000 dependent applications filed because of the changes in the regulations. So that's so much more aligned with what the government was hoping for the sector. But it's undeniable that I think the voices from the sector explaining what the impact is going to have on service provision is going to remain fundamental. And there's going to be ongoing consultations from the likes of the Migration Advisory Committee in future that we would encourage everyone to engage with, to make sure that government are aware of what impact these changes are having, so that can feed into possible new iterations of the rules as they come in. And that's going to be an ongoing consultation process for the next at least 12 months, as far as we're aware. So as and when that arises, we do encourage you to participate in that as you feel able to. So that's kind of talk about the politics and the policy changes and what that's been doing to the numbers. One thing that I would probably note is that although we did have a statement of changes in October, there was effectively a bit of a pause in the implementation of the white paper between July and October, as we had that change in ministers. So a little bit of breathing space to adjust and to kind of come to terms with the new policy environment. But that being said, there's no rest for the wicked. So what we have seen in the interim, as well, the immigration rules weren't necessarily changing a huge amount between July and October. And I do remind myself that's a fairly short period, especially in the world of business. But what I did want to really draw your attention to is the absolutely huge increase we've seen in Home Office resources going towards enforcement and reviewing businesses to see where there are instances of non-compliance and illegal working. So what I wanted to share on the screen here was some graphs that show really the marked increase in enforcement activity from the Home Office, in particular from 2024 until this year. And I'm sure by the end of this year in December that the data for 2025 will show a further increase. But what you can see there is on the left-hand side, the value in pounds of illegal working penalties that the government have issued in millions. And on the right-hand side of that graph, the number of illegal working penalties that have been issued. So not only is the value of penalties on employers going up, but also the number of businesses or the number of penalty notices that the government are issuing. And that's really being driven by a sharing of data. So we did hear from the head of work visas that they're doing a lot of work with HMRC, looking at payroll data for sponsored workers to establish and check that they are being paid the requisite salary in line with the visa thresholds to remain eligible for that visa. So in particular for this sector, where people work on shift patterns and they're not necessarily paid a consistent amount week on week, month on month, we're hearing from the Home Office that they're typically looking at data on a quarterly basis, so every 12 weeks, looking at payroll data to make sure that the remuneration that employees in the care sector are receiving are commensurate to the information that's put on their certificate of sponsorship. And where there are found to be gaps in that, then the Home Office are being very quick to issue penalty notices for illegal working. And that, as again, you might say from a government perspective, it's really a virtuous circle for them, because the more penalties they issue, then that's good data for them to say to the public, we are stamping down on rogue employers that don't do the right thing and on illegal working, which obviously is not popular with the public. But not only that, because the level of penalties being raised is going up, then that's also making substantial income for the government, which we're coming up to the budget shortly, but we know that there's a lot of economic pressure on the government and gaps and deficit. So the more money that can be raised through different means, and so in this angle through illegal working penalties, then again, that's only a positive from a government perspective. And that's, from a Labour government perspective, again, cutting down on abuse of workers that aren't being paid properly is all part of the mandate. So these numbers, in my personal view, will continue to go up. But what I did want to share is also the experience we've had with a lot of employers that have started to receive these notices. So one thing that's usually the process that takes place with illegal working penalties is the Home Office would issue a notice of intention to levy a fine, but would then give an opportunity for the business to respond and explain, or to make representations as to why a penalty may or may not be appropriate. And by cooperating with that, there's an opportunity for employers to reduce the amount of penalty that might be levied if you do have instances of people that aren't working in line with their visa conditions. And I want to be really clear that illegal working penalties are not just for somebody that doesn't have a visa. Or it can certainly apply to people that have a visa, but they're working more hours than they're permitted to. So we see that a lot with students, for example. If they're working in excess of their permitted 20 hours, that would still constitute illegal working. So you do need to think about this more broadly, that it's not just about someone that you didn't do a right to work check on, but are you in line with all their permitted visa conditions? And I think in this sector, the most prevalent issuance of illegal working penalty notices is where you've got employees that are doing supplementary employment. So they might have another sponsor, but do up to 20 hours a week of additional work with yourself as their employer. And that can be very difficult for you to monitor, but get that wrong and that still counts as illegal working, and can make you subject to a penalty. So there is a lot to think about there. But as I say, normally the process would be that the government would allow an opportunity for you to respond to the allegation before they then go ahead and issue the penalty to you, if that's appropriate. What I have seen increasingly is that there's been less of a consultation and a direct issuance of a penalty notice straight off the bat, which employers can still contest. But it feels like a rather different process when the penalty notice arises, and I say a demand for £60,000 payment, which is as high as it can be just for one illegal worker, can be quite disconcerting and can cause a lot of panic and concern when that lands on the desk. And the other thing that's a little bit odd about that is not only are they always following a process of having an initial request for information before levying the penalties, but often the penalty notices are being issued in the post as a hard copy letter without any email correspondence to the employer. And actually, when I first saw these notices, I thought, gosh, that looks like a scam. So we had to go to the Home Office to verify that it was a legitimate communication from them. So what I would say is, if you have multiple site locations, which I know many of you will do, is make sure the message gets out to all your site locations to put them on notice. If they receive any communication that might look like a Home Office document, they really need to escalate that to the appropriate point in the business so it can be verified and responded to accordingly. That being said, what I did want to share is some positive news, is that it does seem like some of the data that these penalties are being raised on the back of is actually quite often inaccurate. So a lot of employers that we've managed to look at and support with have managed to get these the penalty notices rescinded and cancelled without having to pay any penalty at all. So there is a lot of success stories there. So it's not a given that you will have to pay necessarily, but it does obviously cause a lot of concern and panic. And I think when everyone starts to do a reflection on their processes for things like right to work checks, you can often find that from an internal audit perspective, there might be things that you could be doing better. So just to share that, it would be better to do a pre-audit now before getting landed with one of these notices, because as I say, you don't get much time to respond, and it can be quite disconcerting and a very stressful time for businesses. So that's illegal working notices and a lot that's been going on in that sector. But separately to that, which I know is also impacting the health and care sector very heavily, is the number of sponsor license revocations and enforcement action that's being taken. So as a sector, we know that the government are looking very heavily at sponsors of health and care visas. And what we're seeing is it used to be a lot of whole-scale audits where they'd come in for 1 or 2 days onto your site premises and look through your files and then write a report. Those days are largely gone, and what we're tending to see is electronic requests for information, and spot checks for compliance are much more frequent. And then you can see there, as a result of that increase in frequency of investigation, the number of license revocations have gone up by a huge amount. So there was 261 license revocations in July 21 through to 22, but in the year 24 to 25 there was almost 2,000 sponsor license revocations. And at a meeting we had with the Home Office, again, head of work visas was very clear that he expects that number to go up again for the year 25 to 26. So when we're working with organisations that have been approached by the Home Office and asked to provide data and evidence of sponsor licence compliance, where you're sponsoring international workers, what we're tending to see is things that we might historically have thought, wasn't ideal, and certainly had room for improvement in terms of day-to-day practice with a licence. The Home Office used to take a little bit more of a pragmatic approach to say, well, look, we can see that overall you're trying to be compliant and give you a bit of a slap on the wrist. I think what I'm definitely seeing now is when the Home Office do come in to make an inspection, they're taking those breaches far more seriously, and licenses are being revoked on the basis of non-compliance, where historically, I say, they might have given you a bit of a slap on the wrist, but we're willing to forgive. And these days, there's a lot less pragmatism in the outcomes of those findings, because there is an absolute onus that if you are going to be a sponsor, you need to take this very seriously and put the appropriate resources to it, in particular for this sector where there has been a lot of abuses over the last few years in particular. So now, obviously, the challenge with that is that if you get your license revoked, it's not just potentially one or two workers, but it could be a substantial part of your workforce that immediately then lose their right to work for you. And indeed, if they can't find an alternative employer to move to, might have to leave the UK along with their family. So the disruption to both the business and the employees and their families could be absolutely huge if the license was to be revoked. And I say a number of organisations that we have seen, they're issued with, in the first instance, a notice of intention to revoke, where they identify all the issues with the licence, and then there's then time again to respond to that. Now, that's a very fixed process, and there is a two-way process of communication with the Home Office on that. But again, overall, the sense is that if there are repeated and systemic failure, that will be taken in the round to deem that you're not a suitable sponsor. So again, checking your homework now, going through your files and processes and making sure you're really clear on what your duties are as a sponsor of international workers is absolutely essential. And one thing I also wanted to flag is when licenses are interrogated by the Home Office for compliance, they won't just check your files for those workers that you sponsor under the health and care visa or the skilled worker visa. They will also look at files for non-sponsored international workers that might have spousal visas or student visas or ancestry or any other category. And they'll also look at your processes for sponsoring, for hiring and recruiting British nationals and your right to work checks. So the license audit process is pervasive across all aspects of your business. So again, if you are doing a bit of a tidy up, absolutely do start your initial focus on your directly sponsored workforce, but don't forget the broader demographic of workforce as well, because it all comes into play when it's being inspected by the Home Office. So there's quite a lot to think about there, and I think there's only one direction of travel for this, and that will be more revocations and more enforcement action in the months and year to come. So that's kind of a whistle-stop tour of what's been going on with enforcement in terms of at a license level. What I also wanted to share is for sponsors, and so you might not be subject to an audit immediately, but you might have visa applications, extension applications, new hires, people switching visas from inside the UK. We're also seeing individual visa applications being interrogated a lot more thoroughly. So applications are being filed and they're taking longer to process, which can be frustrating for the workers, especially if they've got holidays planned. So what we're saying is factor in more time for applications to be processed while the application is scrutinised, but also leave a lot more time to make the visa application. If you're sponsors, you'll know that there's a process of obtaining certificate allocations for your certificates of sponsorship. And we're seeing a real delay. If you need to request more certificates on an annual basis, it's taking quite a long time for those allocations to be granted. And when the allocation requests are being made, again, huge requests for information from the Home Office. as a way of vetting your company operating procedures. So making sure that you're paying workers the correct amount of money, and what is your recruitment process, etc. And also interrogating the candidates themselves as do they have the suitable skill sets for the roles. So we are seeing more applicants being interviewed and questioned by the Home Office to verify that they have the skills to be doing that job. So really the practical advice there is to plan ahead and allow lots of time, and do make sure you're logging into your license frequently to get ahead of if you need a certificate allocation. It's taking well in excess of 10 weeks, up and up to 18 weeks. So don't leave yourself short because the priority service isn't always available. So planning ahead really is very essential. But I'm now going to pass over to Sara, who's going to give you a little bit more information around the sorts of questions we're seeing specifically around certificate allocations. I know this is a day-to-day activity for Sara with a lot of our clients. So Sara, over to you.
Thank you. So a hot topic at the moment is in relation to certificate of sponsorship allocation issues. There has been massive scrutiny in the past few months in regards to certificate of sponsorship allocation requests. Previously, sponsors were able to apply for more certificates, request priority services in order to expedite the request from roughly 18 weeks down to 1 week once a priority slot had been successfully obtained. However, what we have been experiencing in the past few weeks is that the UKVI are now sending the majority of organisations a request for further information before they're willing to consider their request for additional certificates. This is also regardless of the sector that the organisation is operating in. What we're noticing is that the requests for information are usually to be provided within 1 week, and it is quite a long, extensive list, which is including further explanation as to why more certificates are needed, a detailed description of each post that the certificate of sponsorship is required for, an up-to-date hierarchy or organisation chart, last 6 months business bank statements, and a full pay run report or payroll summary. This can be quite difficult or challenging for some organisations to be able to pull together within 1 week. So what we are advising our clients at the moment is once you put the certificate of sponsorship allocation increase request in, start gathering all of these documents just in case you are one of the unfortunate organisations that are targeted for these documents before the Home Office are willing to process your request. The good news is that once organisations do provide these documents, they are likely to see their allocation requests be approved very shortly thereafter. Another thing that I just wanted to touch upon in relation to certificate of sponsorship allocation issues is that there are currently only 60 slots available each day, which open from 7 a.m. and before even 7:01 a.m. they are all completely taken. There are some organisations that are trying for several weeks before they manage to secure a priority slot, if they even manage to secure one at all. What we are therefore really strongly advising is that you're regularly logging into your license, checking how many certificates you have left, and planning ahead and requesting more in good time, particularly if you have any sponsored employees with visa expiries coming up in the next few weeks or in the next couple months. Make sure that you have enough certificates available to use for their renewal application, and if not, that you're putting that request in good time, especially if you are unable to secure one of the priority slots. Just as a reminder as well, the number of certificates showing on your license summary is for applications which are made from within the UK. So for extensions, switching to the work visa route, or change of employer. Any applications made from outside of the UK require a defined certificate of sponsorship, which is applied for on a case-by-case basis. Moving on now, as you may have seen in the news, Scotland's First Minister has criticised Westminster's immigration policy, surprise, surprise, and has announced his plans for the Scottish Government to directly sponsor hundreds of care home workers in order to ensure that care homes remain staffed and operational as part of a wider push for Scottish independence. However, unfortunately, this is unlikely to go ahead given that there are no devolved immigration powers. If immigration powers were devolved to Scotland, then that would mean that the Scottish Government could set its own visa rules and criteria, create immigration routes tailored to Scotland's economic and demographic needs, and also decide how many and what types of migrants can live and work in Scotland. We're expecting quite a lot of changes to immigration policy, with these expected to be fully rolled out by the end of Parliament in 2029. It was recently announced back in October last month that the immigration skills charge will be increasing by 32% from the 16th of December this year. 32% being quite a significant increase. At present, it's £1,000 per year for medium and large size companies. So this will be increasing to a staggering £1,320 per annum per year per sponsored worker. What we're strongly advising is that you're submitting any renewal applications now if you're able to do so in order to take advantage of the current lesser fees. In terms of the settlement residence requirement changing from 5 to 10 years, most notable is the expected announcement on whether businesses will have to sponsor workers for 10 years instead of 5 years before they're able to acquire indefinite leave to remain. If they will be doubling from 5 to 10 years before these individuals can acquire indefinite leave to remain, this would double the cost for employers from £12,000 per worker to nearer £25,000 based on today's fee rates. Visa fees typically go up around every April, so these are just based on today's rates. We're waiting for further information on this and who exactly will be impacted by the 10-year route. However, it does appear that this will apply retrospectively. We are waiting for further information. I know a lot of employees are extremely anxious about this at the moment. We receive emails extremely frequently from clients asking whether they're going to be impacted, if it's going to apply to new visa applicants from a certain date, will it be backdated? We're waiting for more information on this at the moment. There's also plans to reduce the graduate visa duration to 18 months. This has now been confirmed to take effect from January 2027. The planned shortening of graduate visas from 24 to 18 months will therefore require careful consideration from employers and puts pressure on employers to offer sponsorship sooner in order to retain talent. The reduction from 2 years to 18 months as well will directly affect employers' graduate recruitment strategies, so that's something to be aware of. The original 2-year period did obviously give employers greater flexibility in terms of assessing international graduates before deciding whether to sponsor them. So this will mean that those that are impacted by the reduced visa duration will have their employers having to decide sooner rather than later whether to offer sponsorship to them or not. We've also had confirmation last month in October about the increased English language requirements for workers. So from the 8th of January 2026, this will be increasing from level B1 to level B2. At the moment, there's no confirmation as to when dependents will have to satisfy the English language requirement as well. But at present, it's just been confirmed that workers will be required to demonstrate the level up to B2 now. Put together a couple slides in respect of the most popular frequently asked questions around the care sector, as it can be quite tricky to navigate in terms of all these recent rule changes and what exactly is enforced and what isn't applicable anymore. The most frequent one at the moment being, is the care worker visa still open to new applicants? In a nutshell, no, it officially closed to new overseas applicants from the 22nd of July. This therefore applies to roles under SOC Code 6135 care workers and home care workers and 6136 senior care workers. These occupations have also been removed from both the immigration salary list and the temporary shortage occupation list, which therefore means that employers can no longer sponsor new recruits from abroad for these roles. Other healthcare professionals still, however, can be sponsored. It's just these two particular SOC codes. Now, what about people that are already working in the UK as a care worker? Are they impacted as well? So applicants are now required to have completed a minimum period of 3 months of employment with their sponsoring care provider before submitting a switching visa application. The individual must be able to demonstrate that they've worked in the same role for at least 3 months. And they must be able to demonstrate this usually by providing their last 3 months' pay slips in support of the visa application. What we also suggest as well is that on their certificate of sponsorship, you add a sponsor note in, which confirms that the individual has been working for your organisation for the last 3 months in this relevant role. Now, in terms of salary requirements for extending a care worker visa in the UK, it is a little bit unclear as to what these requirements exactly are. So at the moment, in order to extend a health and care worker visa, the salary that must be met is the higher of two thresholds. That's either £25,000 per year, so £12.82 per hour, or the occupation-specific going rate. So just want to make clear that these figures are based on a 37.5-hour working week and must be prorated for any other working patterns. The transitional salary level is lower than the general skilled worker threshold of £41,700 per year, which makes it an attractive route, and is designed to support care workers that are already employed in the UK. These transitional provisions will remain valid until 22nd of July 2028, after which further changes may apply. And finally, can care worker visa holders bring dependents to the UK? I know Sacha briefly touched on that earlier on. So dependents, which are defined as partners and children under 18, can still join or extend their stay if the care worker's visa was granted before the 11th of March 2024, so that being the key date, and that the applicant meets conditions such as remaining with the same employer or within the same occupation code. For any visas granted on or after the 11th of March 2024, new care workers and senior care workers, so those that fall under stock code 6145 and 6146, are no longer permitted to bring dependents with them to the UK. That restriction was introduced as part of the broader immigration reforms and was aimed at reducing net migration. As you could see in the earlier slides that Sacha showed, there has been a significant drop in the number of applications made by dependents of those in the care worker route because of these recent changes. Importantly as well, other roles under the health and care worker visa, such as nurses or midwives, remain eligible to be accompanied by qualifying dependents, provided that they meet the standard requirements. At the moment, it's just stock code 6145 and stock code 6146 that are impacted and can no longer bring dependents as of the 11th of March 2024. Those were just the four main questions that we receive a lot from our clients, but if there was anything else that we haven't covered within the slides today, I appreciate a lot of information has been thrown at you, a lot of high-level information and still quite a little bit of uncertainty as well, then please feel free to drop your question in and we will get back to you as soon as possible. Thank you so much for joining us today. We really hope that you found the webinar informative and insightful. And as I said, please do drop any questions in and we'll get back to you as soon as possible. And we hope you have a great remainder of the week. Thank you.
Thank you.